Thank you very much, Director, and I'm extremely pleased and proud to be here with you as the Director of Public Prosecution for the Commonwealth, and I congratulate you on your reappointment, which I think only happened in the last week. And so this is breaking news with the reappointment of Director Sarah McNaughton. And I was proud to attend a meeting this morning of the um, Anglo-Australasian Lawyers Society, where uh, James Rennick, SC, who previously held office as a monitor of security legislation, gave a very interesting talk, making a point which reinforces the point just made by the director, that there has been 123 statutes of the federal parliament in the space of the last 20 years since 9/11, and those statutes have introduced very complex, interrelated, separate legislative provisions, which make it very difficult for anybody, even somebody who is expert in the area, to really know and keep on top of all the changes that have happened in the security and terrorism area of the law. He also made a very interesting point, which I hadn't thought of since I was chair of the Law Reform Commission, and that was the fact that we've muddled along without an act of criminal procedure in the federal sphere, and that uh, whilst that might have been an appropriate and maybe necessary and certainly constitutionally expected state of affairs at the time of federation and for a long time after that, a question does arise in a world of so much federal legislation and increasing activities of federal criminal law and of federal prosecutors, whether it is appropriate to continue to have different criminal procedures uh, in different jurisdictions of the Commonwealth. And that was something that James Rennick raised this morning, and I'm no doubt that will be considered as one of those potential sources of miscarriages or of injustices. I want to mention very briefly how the director got her job with me, because she came along with a wonderful CV, but she had obviously turned her mind to the kind of decision that lawyers have to make, very sharply focusing her mind on how do I get a job with this man. And she said to me, very nice to meet you, Justice Kirby. I'm so honored to meet you, so honored, especially because um, you do not appoint women to the position of an associate. Now, that wasn't entirely true. I had appointed, I think, two women, but in those days, all the judges were males, and overwhelmingly, almost all of the associates and researchers were male too. And the statement made by Sarah McNaughton that it was very nice to be there, but she knew that she was wasting her time, that was a very, very clever tactical maneuver. And it burrowed away in my mind, and I thought, gee, that might well be right. And so I offered her the position. I never regretted doing so, and her glorious career has continued to flourish uh, ever since she was my associate. I take all of the credit and none of the blame, and I'm very glad to be here on such a short time after she has been reappointed. Now, the injustices of our legal system are many, and we don't have time to consider them all. Of course, my professional period from 1975 to 1984, when I was chairing the ALRC, led me to look more closely and more consistently at what could be done to deal with injustices in the federal area of civil and criminal. Uh, but the problem of injustices really goes back a very long time in the history of the English law on crime and the history of transportation of convicts to overseas places where they could be kept more cheaply than in England. That was the course that was followed with the transport of convicts from England to the American settlements until the Americans had their very inconvenient revolution. And it's an interesting historical fact that, notwithstanding the revolution, the English vessels carrying the convicts over to the colony of Maryland continued to come. Even after the revolution, the British never occurred to them that the Americans wouldn't want to keep on receiving them. But very quickly, the American settlements, by this time states of the United States, simply turned the vessels back and sent them back to England. And that led to great pressure in London to try to find another place to which the convicts could be sent. And it was that fact that led people in London to think of the various places in the world where they could deposit these unwanted souls. One place thought of was in the west coast of Africa, but there was too many mosquitoes there and malaria, and therefore that was ruled out. Another place was on the east coast of South America, but for various reasons that was ruled out. And then suddenly people began to talk about James Cook's journal and the temperate climate in the south part of the great landscape, and that led to the first fleet under Captain Phillip, Governor Phillip, and that led to the settlement of Australia. So we are very much tied into the history of English criminal law, and we wouldn't probably be here. Our continent would have probably been claimed in part by lots of European powers, except for the fact that they had to fill the prisons somewhere elsewhere than in Maryland and Georgia in the United States of America. So uh, that was the way we came about. And the criminal law in England during the 19th century continued to evolve, but there was great resistance in the United Kingdom to the adoption of the penal codes that had been uh, uh, devised. There were three great penal codes on offer: the Macnaghten Code, the Fitzjames Stephen Code, and the Griffith Code, devised by our very own Sir Samuel Griffith. Those codes were available for all of the colonies of the United Kingdom, and they were adopted throughout those colonies. And as you know, in three states of Australia and in the Northern Territory in part, the criminal code based on the Griffith Code has been introduced as the basis of our criminal substantive law. But there was opposition in England to codification, and it has never come about in England and in Wales uh, and in Northern Ireland, and therefore the law was a hodgepodge of particular statutory provisions and the common law. And when I learned criminal law at the Sydney Law School back in 1958 under Mr. Vernon Triet QC, I learned it from a book, Cross and Jones, written by two English scholars. And that was just the way we learned criminal law in New South Wales back in those days. Uh, there weren't many common features throughout the British Empire, but one common feature that was introduced in 1907 was the Criminal Appeal Act. And the Criminal Appeal Act provided for the appeals on the merits to be introduced in Australia in the different jurisdictions of the country when template provisions based on the 1907 UK Act were introduced in Australia. In 1912, the Criminal Appeal Act of New South Wales was introduced. That set up a Court of Criminal Appeal that provided for appeals in matters of substantive law, error in substantive law, error in procedure, or unfairness in procedure, and error in sentencing. And those courts of criminal appeal were constituted by the judges of the state supreme courts. And when I was appointed the president of the Court of Appeal of New South Wales, I was entitled to be appointed as a participant in the Court of Criminal Appeal. But for some time, Chief Justice Street had not exercised his discretion to invite judges of the Court of Appeal to sit. For reasons that I won't go into now, that very considerable judge, Sir Lawrence Street, ultimately invited the judges of appeal to participate in the Court of Criminal Appeal. And so by about 1986 or 87, I was sitting quite regularly in the Court of Criminal Appeal of New South Wales, and I continued to do that until I was appointed to the High Court of Australia in 1996. And therefore, every Friday, and often on days earlier in the week, I would interrupt my work in the Court of Appeal and sit in the Court of Criminal Appeal together with two of the judges of the Common Law Division, who we three made up the Court of Criminal Appeal. And I saw how hard the work of the Court of Criminal Appeal was. At first, I was sitting quite regularly with Sir Lawrence Street, and he was an amazing and extremely hard-working and very well-prepared judge. And generally, when he was sitting, he took over the obligation of providing extempore reasons in most of the appeals for both cases of substantive challenge to conviction, but also challenges to sentence or applications for leave to challenge sentence. And so judges could, to some extent, rely on that extremely experienced and talented judge to deal with all of the matters. And he didn't sit all that much in the Court of Appeal. I tried to get him to sit often because he was a very, very experienced judge who had been Chief Judge in Equity, but he was very accomplished in criminal law. I soon learned as it became my responsibility to preside in the Court of Criminal Appeal how taxing and difficult the task was. We would usually have two, sometimes three, sometimes one substantive appeal against conviction. And we would have two, sometimes three, occasionally four applications for leave to appeal against sentence. And we three had to get through those tasks. We would meet as three earlier in the week. We would, the presiding judge would assign the primary responsibility of the Court of Criminal Appeal to the judges equitably, taking a fair load for themselves. And we would then try to get through the work on the following Friday. If a judge, both in civil and criminal appeals, did not feel comfortable with proceeding to an extempore decision, for which, of course, you have to prepare, then that particular matter would be stood over and the decision would be reserved, and that was entirely understood. And if anybody wanted to reserve the decision, the decision was reserved. But you didn't want to do that too often because otherwise that would bank up and you would have a great backlog of work which would hold up the business of the court. And this is at the heart of the problem that I think affects the remedy which was devised in 1907 in Great Britain and followed in 1912 in New South Wales and about the same time in all of the Australian jurisdictions, providing for the template Court of Criminal Appeal. And the problem was that an enormous workload was cast on the judges who constituted the Court of Criminal Appeal as criminal law became more complex and as sentencing law became more complex, an issue that was mentioned this morning by James Rennick, SC. uh, it became more difficult to get the decision of the Court of Criminal Appeal in such a shape that it could be delivered instanter after the end of argument. And yet, to get through the work, there was something of an intellectual pressure upon the judges to try very hard to do just that. The English judges had something of a fetish of finishing all cases on the day of assignment, and therefore we in Australia tried to do likewise. And Sir Lawrence Street had set a very high standard by the way in which he seemed to be able to get through the list. But if you were going to get real input as distinct from symbolic input of the judges sitting in the Court of Criminal Appeal, then the methodology of the Court of Criminal Appeal, with the problems of increasing complexity and difficulty of federal, state, and other laws, became something of a hindrance to getting high standard work completed with appropriate attention to what, after all, were decisions that were affecting the liberty and the reputation of citizens in seeking to exercise their right of appeal provided by the 1907 template and the 2012 and other years in the criminal appeal legislation. And it's in consequence of that uh, difficulty that some judges, but more particularly academic writers and members of the practicing legal profession reviewing the performance of courts of criminal appeal, came to feel that something supplementary to the courts of criminal appeal may well be needed. And the fact that a number of very high profile cases started to happen was an added reason why judges came to feel that putting them under such pressure to reach their decisions accurately but very quickly uh, was not permitting the kinds of investigation, reflection, reconsideration of the way the matter had been presented that really the seriousness and importance of the cases suggested. And the fact that there was a further appeal by special leave to the High Court of Australia, and the fact that occasionally there had been criticism of the decisions of courts of criminal appeal, including of New South Wales, led maybe there was a need for some supplement to the 1907 template that had been followed throughout Australia. The cases which led to that feeling, I don't have time now to go through in detail. They included the Chamberlain case, of course. So famous was that it was the subject of, I think, 3 films, including one that attracted an Oscar nomination for Meryl Streep for playing Lindy Chamberlain. And the Chamberlain case gained a great deal of attention. It went through one inquest and then a trial, and that led to a conviction, and that led to appeals, to further inquests, and ultimately to a royal commission conducted by Justice Morling, and that led in turn to the ultimate acquittal of Mrs. Chamberlain, and the result of a further investigation led to the discernment of what was effectively a very serious defect in the forensic evidence, which had mistaken what was claimed to be fetal blood of the baby who was allegedly killed by Mrs. Chamberlain, but which she said had been grabbed by a dingo. Um, that was confused, and the red item was identified as fetal blood, but later was authoritatively determined to be paint on the inside of the car that the Chamberlains had used to go to the camping holiday at Uluru Ayers Rock. And so the Chamberlain case gained a lot of attention and became one of the parables that I have mentioned in a written paper, which led to increasing disquiet about the methodology that was dependent on the system of courts of criminal appeal uh, effectively alone. And this problem came home to me in a case that arose in the High Court very soon after I was appointed. I was appointed in 1996, and very shortly after that, I think it was 1998, an application came up from the Court of Criminal Appeal in Western Australia for Mr. Mallard to have leave to appeal against his conviction. His complaint on that occasion was effectively that he had not been given, as he had requested at the trial, the opportunity of speaking to a lie detector, polygraph. And he complained that if that had only been done, it would have revealed that he was innocent, and that was denied, and therefore he should be given special leave to appeal. That was not a very convincing argument in the High Court, because Australian courts have, unlike those in parts of the United States, not accepted these lie detector as an infallible method of telling truth from falsehood, and therefore special leave was refused. He got a pretty good bench, if I can say so, Mr. Mallard, on that first occasion. Justice Toohey was presiding, a judge with a lot of experience in criminal law. Justice McHugh was sitting, and I was the third judge. So it was a sort of a dream court for the prisoner, but we unanimously refused special leave. And then about 8 years later, I was reading papers for another special leave hearing, and I thought, I've read these papers before. And this was a further application because Mr. Mallard had eventually gone to the governor of Western Australia and had secured uh, a petition and the permission to refer the matter to the Court of Criminal Appeal again, named the Court of Appeal by this stage, and that led to Mr. Mallard's um, refusal once again by the Court of Appeal of Western Australia of leave to reopen his sentence and to reconsider his case. And so he came up again, and I drew attention to the fact that I had sat earlier in the earlier application, but nobody wanted me to recuse myself. Oh, no, 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 we don't want Your Honour to leave the court. And so I sat in the case, having disclosed my previous involvement with the case, and we heard a very different case indeed. Mr. Mallard had secured excellent counsel. He had Mr. McCusker, QC, who later went on to become the governor of Western Australia, and a really talented and experienced advocate and criminal lawyer. And also we had Mr. James Edelman, who was uh, travelling down to Perth from Oxford, where he was a professor of law, before his subsequent appointment to the High Court of Australia. And they, by very close analysis and the detail of the facts, demonstrated that two objective items which fixed time, so far as Mr. Mallard was concerned, were not compatible with his being in that part of Perth where a jeweller had been murdered, the subject of the charge. And uh, they were his release from the watch house in CBD in Perth and his doing a runner from a taxi on another part of Perth. And he just couldn't have been at the place of the murder in a third part of Perth and have been in those two places objectively demonstrated. There are all sorts of other problems in the case from the point of view of the prosecution, and there was a degree of unfairness in the presentation of the case by the prosecution. Mr. Mallard, it turned out, was a prisoner with mental health issues, schizophrenia, and he, trying to help the investigator, kept making suggestions about how the murder had taken place, but that was just his nature in manifesting his mental disability. In the end, an investigation was conducted by a judge of the Supreme Court of New South Wales by way of Royal Commission, and this found that Mr. Mallard was not only not properly proved to be guilty, but was innocent, and that the murder of the jeweller had been performed by another person who was actually in prison with Mr. Mallard at the time of his conviction. So uh, that brought home to me, who I hope was a very conscientious uh, judge, the fact that, in effect, by not having had the time and the assistance to address all of the issues that needed to be considered to determine fairly and properly the appeal of Mr. Mallard when it came before me in 1998, that led me to the view that something better was needed. And this therefore raises three steps that have been proposed for us in Australia to try to improve the institutional arrangements we have for criminal appeals. And these affect both federal proceedings, but also state proceedings and other proceedings. One of them was the possibility of having a second appeal. At the moment, the Court of Criminal Appeal Acts have been interpreted, including by decisions of the High Court in a case called Burrell and in a case called Postiglione, uh, a decision that the right of appeal provided in the Criminal Appeal Act is limited to one opportunity. Once utilised, the Court of Criminal Appeal, so it has been held, is spent. That is a view of the Court of Criminal Appeal which I disagreed with. And when I was in the High Court, I indicated that I disagreed with that in Postiglione. And Justices Dawson and Gaudron, both of whom knew quite a bit about criminal law, were also minded to think that there was nothing in the statute that confined you to only one, and that by leave or special leave of the Court of Criminal Appeal, if you found new and convincing evidence, fresh or different evidence, and wanted to have a second appeal, then it should be left to a Court of Criminal Appeal to permit you to do that. But that is not the law in Australia, and Postiglione stands in the way of having a second appeal. This has led to amendments to the Court of Criminal Appeal Act, the Criminal Appeal Act, or equivalent statutes providing for the CCA solution. And these statutes have been changed, first of all, in South Australia, our only non convict state. They adopted amendments to their act to permit, by leave of the Court of Criminal Appeal, in the event of fresh and convincing evidence, uh, a second appeal. And that has been the law in South Australia since 2013. That statute was copied in Tasmania in 2014 and in Victoria in 2015. And it was before the Parliament of Western Australia, when it was prorogued and dissolved for the recent election in that state. And it's likely to be adopted in Western Australia, the hometown of Mr. Mallard. The fact of the matter is, Mr. Mallard ultimately got justice and the correction of the miscarriage of justice in his case, not from the judges and not from the judiciary and not from the legal process, but he got it because a few members of parliament were convinced that he was not guilty, and they continued to argue his case. And journalists gave support to their argument. So the provision of redress for Mr. Mallard came not from our profession, but it came from politicians and from the media. And that is not a very good solution. The error prone possibility of the CCA solution, and that the solution that has been adopted, permitting a second appeal in limited cases in South Australia, would be copied throughout Australia. But unfortunately, no steps have been taken, so far as I'm aware, to replicate the South Australian provision in New South Wales, in Queensland, in the Northern Territory, or in the Capital Territory. And the question is, why hasn't it been done in those jurisdictions of Australia, given the clear demonstration of miscarriages of justice, and the possibility that new evidence, compelling evidence, will be found after the first appeal to permit and justify a second appeal. So that's the first change that is needed. It's a pretty small change, but unfortunately it's proved very big for those states that haven't even bothered to or appeared to consider it. The second solution, which has been suggested by a number of commentators, including a very important paper by Justice Maxwell, the President of the Court of Appeal of Victoria, relates to the need for improvements and changes in judicial directions and changes in judicial practice relating to expert testimony, because increasing numbers of criminal appeals are now dependent upon expert testimony, testimony relating to gunshots, testimony relating to hairs, the analysis of hair, testimony relating to residue of the use of guns, and so forth. And the need for an improved system of, the use of the testimony of technological kind is needed, as was shown in a case called Button, a decision of the Court of Appeal of Queensland relating to a very late analysis of semen on a bed, where a rape was said to have occurred, where it was shown conclusively that the semen was not that of the prisoner who had been convicted. Um, but protecting the testimony, protecting the evidence, ensuring that there is no instance of the giving of presents, which is sometimes said to be the way in which official records have been manipulated to achieve the forensic evidence, and having proper systems for the safeguarding of the evidence in neutral and safe hands is a matter that still awaits determination in Australia. Now, the third possibility is, in a way, the most significant for the point of view of addressing the matter that I've mentioned to you, the difficulty of requiring of judges in courts of criminal appeal that they get through an extremely arduous list in very limited time. And this is a development that has happened in Great Britain in the establishment of the Criminal Cases Review Commissions. Uh, that has been done in the United Kingdom uh, following a royal commission in 1991 conducted by Lord Runciman. He, you would need, in order to change the CCA system and supplement the CCA system, which had operated then for 100 years almost, you'd need something pretty powerful to move the English legal system to make a change. But something very powerful happened. There were a whole series of cases in the 1990s, which were known as the Irish cases. There were the Birmingham Six, and there were the Maguire Four, and there were other cases where large numbers of persons had been convicted, and a clear decision was made later that, on analysis, that those convictions were unjust. And that led to a royal commission into the whole system of English criminal justice by Lord Runciman and 10 commissioners, and that led to the proposal for a Criminal Cases Review Commission. And the Criminal Cases Review Commission was set up in 1997 in the United Kingdom. It was set up originally for England and Wales and subsequently for Northern Ireland, and later in 1999, a Scottish Criminal Cases Review Commission was set up in that part of the United Kingdom. And the Criminal Cases Review Commission, since established in those jurisdictions in Britain, has had 27,000 applications, 26,000 have been dealt with, 260 cases have been referred by the Commission, and of those 760 cases, 689 have been heard and 466 have been allowed. Now that's 3% of the total number of cases that have been the subject of complaint. In a number of cases, 210 that have been referred, the case was dismissed. But in the majority of cases, 466, the cases have been allowed, and some very serious cases of miscarriage of justice have been found, including in cases involving murder and other serious crimes. And the advantage of the system which was suggested by Lord Runciman and his colleagues is that it seeks to address the overwork of the mechanism which had been devised in 1909, and it seeks to institutionally address the problem of overloading the judges of the Court of Criminal Appeal and providing, in appropriate cases, for a staff with resources, with talent, with police and other members, with experts in forensic evidence, who will have the time and the expertise, not dependent on the particular constitutions of Court of Criminal Appeal, but able to look closely and in more detail and without the same time pressures at the cases concerning criminal appeals. Under the Runciman proposal, the courts retain the final say, and they don't replace the decision by the decision of bureaucrats in the executive government. They leave it as a decision of the judicial branch, but it goes back to the judicial branch after it's been considered by the Criminal Cases Review Commission. Since the UK Commission has been established, in 2020, New Zealand established a Court of Criminal Cases Reviewed, and that, not a court, a Criminal Cases Review Commission, and Mr. Colin Carruthers, as QC, has been appointed the commissioner, and he is based in Hamilton in New Zealand, and that body is now set up and is working and is hearing complaints by any person who believes that they have suffered a miscarriage of justice. And in Canada, at the end of 2019, Prime Minister Justin Trudeau, facing an election, said as part of the program of the Liberal Party of Canada that they would establish a Criminal Cases Review Commission in Canada as being a more satisfactory way to supplement the courts of criminal appeal. In Australia, the establishment of such a body was proposed in South Australia in 2013, and that was considered by the Parliament of South Australia, but having decided that they would permit a second appeal, the Parliament of South Australia was apparently exhausted by its reform effort, and it left it at that. And no jurisdiction of Australia has set up a Criminal Cases Review Commission, as is busily at work in the United Kingdom and is working in New Zealand and is about to be established in Canada. A consultation process was announced, I think, last week by the Minister of Justice in Canada for the purpose of setting up such a body in Canada. So the question ultimately comes down to this. If we find from cases like Chamberlain, from cases like Edward Splatt, cases like Eastman, cases like Henry Keogh, and other cases, which some of the four named have arisen in South Australia as a result now of the second appeal facility. If we find that such cases occur, and if we hear of a case like that of Cardinal Pell, 2020, 94 ALJR 394, that making full allowance for the advantages enjoyed by the jury, a significant possibility exists in relation to the charges that an innocent person has been convicted. If that is something that can happen to a degree in Australia and includes figures of the kind that have occurred in the United Kingdom, we really have to come to a question of whether we in Australia are immune from these mistakes or injustices, or whether we just don't care about them and we don't feel any need or obligation to fill the gap and to provide an institutional mechanism for dealing with the cases of unjust and wrongful convictions. So that's basically what I came to say. We rose out of the criminal justice system of England. We went through the 19th century with many injustices in the system. Some of those injustices were cured in the colonies, whereas they were not cured in the United Kingdom. The great template of the 1907 Criminal Appeal Act was adopted throughout the colonies of the United Kingdom and is still in force. It does much good work and reveals cases of serious injustice, but not everybody can afford a Malcolm McCusker and a James Edelman to represent them, and not everyone can afford Brett Walker to represent them in the High Court of Australia, and therefore something more regular and normal and routine is needed, and that's something I think is a second right of appeal in cases of fresh and compelling evidence. It is an improvement in the system of forensic evidence, its safeguarding and its accuracy and its expertise, and a criminal cases review commission which could deal as a failsafe against the possibility which we say is one intolerable to our system, which is that an innocent person might have been convicted of a serious crime or any crime that requires correction. So I place those ideas before you, and following on what James Rennick said this morning about a court of a criminal appeal act for federal jurisdiction, um, it may be that this is something that should be referred to the Australian Law Reform Commission or otherwise tackled with something of the same enthusiasm, resources, and funding that is evident when our federal parliament and its politicians deal with issues such as the production of 123 statutes dealing with security um, and terrorism offences. Thank you for having me. I remain optimistic and idealistic about our system of justice. I've been involved in it a very long time, but I've never lost my commitment to our belief that we are officers of justice and we have a duty. We have often imperfect laws and imperfect resources, but we have a very noble office, and prosecutors particularly a very important office. And I thank you for inviting me to be a participant in this webinar.